Welcome all to the 64th 5 o'clock Club HR Network Breakfast Seminar. We've got a great program today covering our annual legal hot topics. And they're very hot. It'll warm us up. So first of all, getting things rolling, I'd love to introduce our CEO, Darren Kimball.
So welcome everybody. Let's see here. Welcome everybody. I'm really glad to see everybody for a couple reasons. One is that we learned a valuable lesson. We learned it the hard way with regard to this seminar. We learned that putting the word sexual in an email invitation is the fastest way to get it to go right into the spam folder. I'm referring, of course, to our topic of sexual harassment and nothing else. But we have a great program today. We've got some great speakers. We have two of our highest rated legal speakers that have returned, and we're pleased to have a dynamic newcomer with us as well. One note on the question and answers, the questions and answers for the panelists. We're going to do things a little bit differently than we've done in the past. We're going to ask you to tweet in real time your questions for the panelists. They're not going to answer them in real time, but we'll have them ready for the Q&A, which will ensue after each of the panel presentations. So what you're going to want to do is to tweet to hashtag TFCHRNetwork. And if you're not a big tweeter, there's really nothing to be concerned about because we'll have a mix of online and in-the-room questions, so you'll still be able to ask your questions. So here's a look at the agenda for today, and normally we would kick things off with the audience survey, but my understanding is that we're having a little bit of a technical difficulty. Is that still true, Hector? So as you know, we have launched an expanded and enhanced HR Hero of the Year Award this year. And what we did is we broadened it out to 4 categories, and we also put the nominating process in your hands, the HR Network. So I just want to thank everybody who participated in the process. And I'll tell you that we learned some really impressive things about a number of you. And now it is time to announce our 4 HR finalists. For volunteerism, we are recognizing Fred Strobel for his inspiring and tireless work as the vice chairman of the 9/11 charity known as Tuesday's Children. For mentoring, we're recognizing Suzanne Jakstovich, who is credited for inspiring people both personally and professionally in a way that changed their lives. For terminating with dignity, we're recognizing Minerva Garcia, whose supporters praise her strong advocacy of those affected by staff reductions and for her adherence to a robust and fair process. And for taking risk to elevate the strategic role of HR, we're pleased to recognize Eric Lang, whose leadership, determination, and vision were pivotal in taking the HR function at the 92nd Street Y from the sidelines to the front lines of that organization. So there's a lot more to be said about the finalists at the HR Hero reception that we're having on March 11th, and at that time we'll also be announcing the HR Hero. So at this point, please help me give a big round of applause to the finalists. So now just a few words about the 5 o'clock Club. You probably noticed some changes today, and I just want to reiterate that the most important things are very much staying the same at the 5 o'clock Club. And that is our focus on premium service without a premium cost. We provide more of the things that really matter in an outplacement solution, like more private coaching hours per dollar spent than anyone else in the industry, a higher level of engagement to make HR's job just a little bit easier because you have the knowledge that you're doing the best thing that you can do for your outbound employees. And longer duration packages so that career changers have the time and the resources to be successful. So I just want to thank our nearly 500 corporate clients for the trust that they've put in us, particularly those that are represented in the room today. And if you're not a customer yet, we certainly love the opportunity to add you to this list. So before we move on to the main event, let me just cover a couple final housekeeping notes. You may have noticed in your handout the conspicuous absence of the blue form. The famous blue form is where we ask for your feedback, and we've gone paperless. It's in part our effort to save blue trees. So Dr. Seuss and the Lorax, I think, will really be happy about that. I do understand the trees are not actually blue. So if you could look for an email survey that'll come to you a little bit later today, please click through. Your feedback is still incredibly important to us. I also want to mention that our next event is March 27th, and the topic is Navigating the Assessments Maze. It's a great topic, and we really have some terrific speakers, and you'll hear about that via email in a few days as well. So let me just check with the panel. Are we good to go on the audience survey? Okay, so we're going to just sort of keep pushing on. So let me give a proper introduction to our moderator, Mark Moyer. Mark is, in addition to being a star coach, he is a veteran search executive, and as you may have picked up on, in his spare time, he's also a stand-up comic. And now that I've said that, I've raised the expectations that you have in the audience for him being funny to a level where there's no way that he will be able to. So, Mark, for that I apologize. It's your show now.
Yes, it's true. I am a funny guy. However, this is a fairly serious topic, so I won't get into a lot of jokes. One thing I will tell you, though, is that both Darren and I woke up this morning, realized it was going to be quite cold, and instantly grew beards. It saved about a degree or two on our faces. Anyway, without getting on too much with the funny stuff, I'd love to start introducing our panelists, but one quick reminder. Once again, we've entered the 21st century here at the 5 O'Clock Club, and we're happy to receive your questions via Twitter. And again, the address is hashtag TFCHR Network. So for many of you that might be a little hesitant to raise your hands in front of everybody else, you can raise it via the internet, and I'll read them out. But if you could, please address each question to the specific panelist you'd like it addressed to. Alrighty, so our first speaker is going to be Francine Esposito, and if you want to see detailed bios of everybody, you can check it out in your program. I won't read through all of them, save some time here. Francine is a partner at Day & Pitney, and she will be discussing avoiding FMLA abuse. Francine, come on up. Thank you.
How do I move it forward? Just do this? Yeah. Okay. Ooh, he's right about that spotlight. Good morning, everyone. I'm going to do my own audience survey since the technology's not working. How many of you were around when the FMLA was first introduced in 1993, or doing your jobs back then? So this law has been around for 22 years, and you would think we would get the hang of it by now and so easily administer this law. But as you know, administering FMLA is far from simple and easy, and it's so incredibly complicated. And unfortunately, very often your employees abuse the rights that they are given under this law, whether it be the person who seems to always have migraine headaches on Fridays during the summer, or how many of you have a unionized workforce, at least partly? Okay, I find that unionized employees know the FMLA really, really well, probably better than their supervisors do. And, they use up all of the paid time off that they have under the collective bargaining agreement, and only then do they come down with a serious health condition, and then they start taking leave that they weren't entitled to under the collective bargaining agreement, but they are under the law. How many of you have a very diverse workforce where people go back to their countries on a regular basis to visit family? That's another very common area of abuse. They go back maybe for Christmas, and they may be taking 2 weeks of vacation, and then while they're there, their mother comes down with a serious health condition, and they now need to spend more time there. So those are just a couple of examples of how FMLA abuse may occur, and I'm going to hopefully give you in 15 minutes, I could talk about this topic for 2 days, but in 15 minutes I'll give you as much insight as I can about how you can deal with FMLA abuse. Now, first and foremost, I think you need to know the basics of the law. If you're going to aggressively apply the law and try to curb abuse, you need to make sure you know what you're doing, because when push comes to shove, your employees may sue you if you don't follow the law. So you want to make sure you understand the law and apply it correctly. But one of the most basic things that I find very often my clients don't do is to check that employees are currently eligible for leave. So often they're in the middle of a difficult leave situation, and I look at it, I'm like, well, wait a minute, they didn't work the 1250 hours to be entitled to this, or they weren't here long enough, or they already used up all of their entitlement, and they shouldn't have gotten this leave in the first place. So always, always, always check to make sure that the employee is entitled to leave in a particular circumstance. And it's not just the 1250 hours or the year of service, but the 75-mile radius. Very often we forget about that. So if an employee is in a remote office, they may not be entitled to leave at all. And as I said before, that they have not already used up their entitlement. Require employees to provide appropriate notice. As you may know, they have to provide 30 days notice under the FMLA to the extent that a leave is foreseeable. One of the examples I can think of is, let's say, one of those employees who goes to their former country to visit their family, and then they have this serious health condition come up, and arguably that would have been an unforeseeable situation for which they could not have given you leave. But let's say when they come back and you investigate further and say, you know what, when did you make your plane reservations? And what date were you leaving and what date were you coming back? And you may actually see that they made their plane reservations knowing that they were going to extend it. And they did it a long time ago, so they should have given you notice for that. So there's a lot of ways to look at situations and uncover some abuse that your employees may be engaging in. The next thing is the certification requirement. I'm going to spend a decent amount of time on that topic because, again, I don't think we take advantage of the certification requirement as much as we should. But as you may know, employees are required to give you complete and sufficient certification evidencing their need for leave. Complete means it's fully filled out. Sufficient means it's not vague, right? And again, I'm going to go into that more, but you should take advantage of that as often as you possibly can to make sure employees are justifying their need for leave. And we're talking about any leave that has to do with any serious health condition, so whether it be their own or taking care of a family member. Understand the difference between continuous, reduced schedule, and intermittent leaves. You know, generally they should be bringing in certifications where it's a leave related to a serious health condition for all the leaves, but there's a difference between continuous and reduced schedule and intermittent because they have to show that reduced or intermittent is medically necessary. So to the extent that they're taking every Friday off, they have to be able to prove that they need to take every Friday off, and that's medically necessary. Beware of varying state law requirements. How many of you have locations in more than just one state? That makes FMLA administration so much more difficult depending upon the states that we're talking about. Luckily, New York is easy, and it's just what the federal law provides. But just cross the Lincoln Tunnel or the George Washington Bridge and things become so much more complicated because the New Jersey law provides family leave but not medical leave. So that means employees can almost get twice the amount of leave that they otherwise would, because they'll get up to 12 weeks under federal law and then another 12 weeks under New Jersey law. And the way that this came about is just recently I had a client in Texas who had an employee in New Jersey who had a baby, and they gave her 12 weeks of leave both for her own incapacity and to care for her new baby. And then some time goes by and she asks for another 12 weeks. And this client calls in horror saying, she's entitled to another 12 weeks? I'm like, yes and no. Had you known that originally, you could have had it run concurrently, but you didn't know that. You didn't do the requisite designation of the leave as a New Jersey leave as well. So yeah, technically she's entitled to another 12 weeks. So know the states that you're in, know the laws of the states that you're in to be able to take advantage of running leaves concurrently where appropriate. And last but not least, ensure that any peripheral policies that you have are not overly generous. I know a lot of you are from very large organizations, and you tend to be generous, and that's great. And if you choose to be generous, that's great, but know the effects of some of the things that you're doing may in fact encourage abuse. If you give very generous paid leave, like salary continuation programs, that may encourage people to stay out longer than they otherwise would. And to the extent that you have those types of policies, you should put conditions on entitlement to benefits. You have to cooperate with us with regard to certification. You have to, update us periodically in order to continue to get those benefits. Also, what does your FMLA policy say about the requirement to use paid time off during FMLA leave? Do you force them to use all of their paid time off before being entitled to other benefits? And not have that time available to them after the fact. So if they're using up their valuable vacation during a leave, they may not necessarily want to do that. All right, as I said before, certification is extremely important. I'm assuming that you know when you can and cannot ask for certification, so I'm not going to spend a lot of time on this. Ultimately, you have to give your employees 15 calendar days from a request. You can ask every 30 days or for as long as a healthcare provider certifies. So if a healthcare provider says an employee needs to be out for 6 weeks, you can't ask every 30 days. You have to wait for the end of the 6 weeks unless there's a change in circumstances or the employee asks for an extension and all the things that are listed on the slide. One of the things that I suggest more than anything else to avoid FMLA abuse is for you to be proactive. If your employees know that you are on the ball and you are scrutinizing everything and are giving them only what they are entitled to, they are more likely to toe the line than if they never hear from you, they're gonna just kind of do what they want. For instance, this 15-day rule about, okay, you request certification, they have 15 days to bring it in. How many of you have to chase your employees to bring it in, and it's very often after the 15 days? I tend to encourage my clients to be very proactive. And by the way, I put together these binders of forms and guidance to help them because, again, FMLA administration is so complex. But I suggest reminding the employees ahead of the 15-day deadline and say, as you know, you're required to bring in this certification. It's day 10. We still haven't received it. Just as a reminder, we need it by day 15. So it helps you not have to chase after them after day 15 to be reminding them. Technically, you could say, it's day 15, you didn't bring it in, it's unauthorized absence, unless they have a really good reason for not bringing it in. But I also tailor the forms to make them more user-friendly. So on the healthcare certification form itself, in the right-hand corner, I put this big box. This form is due back to the employer by, and you put the date on there, you highlight it so that both the employee and the healthcare provider know that they need to get it back by this date. Every little bit helps. Anything that you can do to have both employees and doctors do what you need them to do is helpful, and that's what you should be doing. And also, again, give clear notification. This is a necessary form. If you do not bring this in and it's not sufficient and complete, you will not be entitled to leave. It'll be unauthorized leave, and you may be subject to disciplinary action up to and including termination of employment. I don't know if you want to be that harsh, at least initially, but employees need to know what the consequences of their actions are. And for the people who are not FMLA abusers, very often FMLA situations are a time of chaos. Somebody's sick, something bad is going on in their lives, and they want as much guidance as possible to remind them of the things that they're supposed to be doing. So it's going to help your good employees, and it's going to help you manage the ones who are abusing. Now, doctors. HCPs, as I call them, healthcare providers. They're busy people. They don't want to be bothered by this in the best case scenario. In the worst case scenario, there are doctors who collude with employees and will basically give them any healthcare provider certification form they want, and it says whatever they want. And very often in unionized environment, there's a particular doctor that a lot of the employees go to because they know they're going to get the certification that they want. But again, do what you can to manage doctors, again, including putting on the form, this is when we need it back by, or even giving a stamped addressed envelope for them to send it back to. Or I put on the forms, actually, you can fax this form back to this fax number. Whatever you can do to get the form back is what you should be doing. But also, you need to educate those doctors. Right on the healthcare certification form that the Department of Labor provides, there is a part for you to put what are the essential functions of the employee's job, and you should be giving the doctor a copy of an updated, accurate job description so they clearly know what the employee's job is. If you don't do that, they go off of what the employee says. So again, you want the doctor to be educated about what the employee does so that you can get a real opinion about whether they can perform the essential functions or not. I don't know if any of you know GINA. When GINA first came out, I ran around the country speaking about it like the sky is falling. Oh my gosh, this is a horrible, horrible law that nobody's aware of. It has to do with genetic information. So far, it hasn't been so bad, but I'm still waiting for the other shoe to drop. But ultimately, when you ask for healthcare certification forms from your employees for their own serious health condition, make sure you have the GINA safe harbor language on it. Are you doing that? I don't see a lot of heads shaking yes. But basically, you want to tell healthcare providers, don't give me the family medical history of the employees that you're filling these documents out for. And again, you're going to be liable if they do provide that information and you didn't tell them not to. If you gave the safe harbor language and they give it to you, then you're like, I told them not to give it to me. It's their fault they gave it to me. So this is just a protect yourself kind of bullet on this slide. But make sure you put the safe harbor language on healthcare certifications or with the healthcare certification forms. You know, doctors are funny. They don't give you the information that you want and need, and they give you information that you don't want and don't need. So again, as much as you can give clear direction to the healthcare providers, you should be doing that. HIPAA. Very often employers misunderstand what HIPAA means. HIPAA is more of an issue for doctors. They're not supposed to be releasing their employees' private health information. And very often there's doctors who don't do healthcare certifications very often say, I'm not filling this out, it's a HIPAA violation. No, it's not. And the employee really is giving the consent to give the information, but to make doctors more likely to fill out the form, I include on the form the employee's HIPAA consent so that there's no obstacle into the doctors filling out the form. Also, you have the right to ask employees to take intermittent leave or reduced schedule leave for treatment at a time that is least oppressive to your operations. So, you know, they leave for their doctor's appointment on Friday afternoons in the summer when you are busy on Friday afternoons in the summer, and you say, can't you go for your doctor's visit on, you know, Monday nights or Wednesday nights? And so, you know, the doctor ultimately decides when treatment is necessary or when their hours are, but ultimately you could push back on the doctor and say, can't you do it then? So these are some of the things you could do with a healthcare provider that will help abuse. Now, this is probably the most important slide in my presentation about preventing FMLA abuse, and that is look at the healthcare provider forms. So often with my clients, they say, oh, okay, we got it, and then they put it in the file, and they don't really look at it. And there's so much on the form that you can challenge. This is not a healthcare provider. This certification makes absolutely no sense. They didn't fill out half of it, and that's when you have to go back and say, you got to fill out all these things. Test to see whether it actually shows a serious health condition, because very often it doesn't. And most importantly is this bullet, clearly and sufficiently supports a need for leave. And there's a lot of requirements under the FMLA for what is a valid certification. When did the condition commence? What's the definite time frame for leave? Doctors can't say to be determined or unknown. The form very specifically says the the best estimate based on the doctor's knowledge, experience, and the examination of the patient. They are forced to put something down. It can't be undetermined or unknown or not applicable or anything like that. Medical necessity, expected duration, all of that. And sometimes the form is internally consistent. Well, okay, this doctor first started treating the employee in March. How can they certify a leave for January? They didn't even know this employee at that point. So really look at it, become like a Sherlock Holmes and scrutinize it very carefully, because this is what you can stand on. Having this form be accurate, complete, sufficient, and very often it's not. And is the form in any way suspicious? 2 different handwritings, 2 different color pens, white out, anything like that, it means that the form may have been doctored. So you want to look for things like that. Use your available tools. One thing that's not on here is your supervisors. And unfortunately, they're part of the problem because they don't tell you that their employees are absent until they're all frustrated about it, and then you say, well, why didn't you tell me? This is FMLA, and we should have designated it. So educate your supervisors about what they should be telling you about their employees' absences so you can be more proactive, and that's important. But all of these are very legalistic, and again, I know you're probably somewhat concerned about doing these things for fear of doing it wrong, and that's why it's important for you to have good legal counsel helping you through all this. But again, if the form is not sufficient, it's not complete, if they didn't fill out the whole thing, you have to give the employee 7 days to cure it. These are the things that we need your doctor to fill out, and you have to tell them that. You could seek authentication of the certification. You could call the doctor's office and say, I have a certification from your office dated this date for this employee. Did you give this to this employee? And every once in a while, you'll say no. They'll say, no, we didn't give it to them. Can you fax it over to us so we can look? And you'd be shocked at how often that actually does happen. With the employee's consent, because you're getting some more detailed information, you should seek clarification of a healthcare provider certification form. Doctors traditionally don't have really good handwriting, so you could say, what is that word? I can't read it. Or what does this mean? You can't really ask for more information, but you could seek clarification of what they did write. Modify job requirements if appropriate. Now, a lot of employers don't realize this. So let's say your employee has 10 essential functions of their job. They can do 9 out of the 10. Now, technically, they're entitled to FMLA leave because they cannot perform all of the essential functions of their job. But what if you say, we don't really care for the next week or 2 or 3 about essential function number 10, so come and do all of your other 9 essential functions. And the employee has the legal right to say, no, I can't do all my essential functions, I'm entitled to leave. But if you're offering them available work, they may forfeit either their workers' comp or their short-term disability benefits. And so if they choose to be out, it's going to be on an unpaid leave. So they may not choose to do that. So again, think about that. Also, not on this slide is something you might want to consider, and that's transferring your employees to an alternative position when they have foreseeable reduced schedule leave or intermittent leave. And you're not supposed to do it to interfere with leaves and put them in a job that's really menial and embarrassing. That's not what you're supposed to do. But very often when you put them in a job that they don't like doing, they're like, I don't want to do this and I want to go back to my other job, and they stop taking leave. So again, I'm not suggesting that you do any bad things to prevent people from taking legitimate leaves for which they're entitled to, but if you have a reason to believe that somebody's abusing, these some of the things that you may be able to do. Another thing that's not taken advantage of as often as it should be, and that's check suspicious patterns with the healthcare provider. Healthcare provider may say, probably about 4 days a month, this person's going to need to be out because of their episodic migraine headaches. And the migraine headaches just happen to be on sunny Fridays in the summer. Why is it that because they're tired from a whole long week of work, and that's usually when the migraines come up. I mean, if that's the answer from the doctor, then that's the answer from the doctor. But that's a suspicious pattern that some honest doctors may say, that's probably not right. And they're probably just trying to get long weekends. And then last but not least, consider surveillance. This is a pretty bold move and an expensive move, but sometimes it pays off. I've had a couple of different cases where this is, and you have to have a good faith belief that there's a problem. And again, you want to check with your lawyers before you do it. But I had a situation where a guy was out with a bad back, and he was videotaped by a private detective on his boat. He lifts his 80-pound dog onto the boat and is working on his boat. And then I had a case down in Atlantic City. You know those big wheels And this one employee who was in charge of the big wheel had a shoulder issue and took a leave of absence from her casino job. But she also had a deli that she owned. And what do deli owners do? On the meat cutting machine. And I'm not a doctor, but I don't know if this motion is any better than this motion. But those are the types of things that you may come across if you engage in surveillance. Last but not least, evaluate reasons to deny leave. And again, this is just a couple of them, but the employee failed to submit complete and sufficient certification, whether they didn't submit it at all, or you gave them an opportunity to cure and they didn't cure it. Again, you can rise and fall on that healthcare certification form. And by the way, you should be requiring that form. So often employers rely on just like a script on a prescription pad, needs to be out for this long, or they work off of the short-term disability form. I would suggest that you not do that. Insist on the healthcare certification form. You get the right information and you get to, again, manage the process with that form. If the certification says it's not a serious health condition, if intermittent reduced schedule is not medically necessary, or if the need for leave is unrelated to a serious health condition. I'll give you one quick story and then I'll let you go. I had a question once from one of my clients. An employee had a developmentally disabled child, and the child did have a serious health condition, and the child had to go to therapy 3 days a week with a doctor, and the parents had to work with the child after the therapy 3 days a week. So the employee asked for, reduced schedule leave or intermittent leave to be able to take off 3 days a week to take the child to this therapy and then to work with the child after the therapy. And it was granted, and that was fine, until the anonymous tip came in from another employee. He's not doing that with his son. He's working at the family ice cream stand. And I saw him out there, and he's out there 3 days a week. So we call the employee in and say, what's going on? We granted you this leave, but you are, at an ice cream stand selling ice cream. Yeah, I know. My son is developmentally disabled. My son does go to therapy 3 days a week. But frankly, I'm not very good at it. So my wife does it, and I fill in for her at the ice cream shop. And this is like 15 years ago. And my advice to the client was, that's not what leave is used for. Either he does the therapy or he comes back to work. It's not for him to work another job. Fast forward a couple of years, there was a case that came out in Louisiana maybe 10 years ago that made me pause. 5 kids, child number 5 has a serious health condition, and the father needs to take leave to care for the child. Mom stays home and takes care of all the kids. And so dad takes off, but dad doesn't take care of sick child number 1. He takes care of healthy kids 2 through 5. And we became aware of this and said, you're not taking care of the child, or the employer in that case did. The employer in that case fired the gentleman, and the court said, well, that's kind of sort of what the law was intended to do, help families in time of crisis. Even though he was taking care of healthy children, and that's not covered by FMLA, the court said maybe. So even when you think you're doing the right thing, you still may be legally liable, but it's important to at least spot the issues. And that's my presentation. Thank you so much.
Thanks, Francine. That was fabulous. She's my favorite type of attorney because she said originally she could go on for 2 days, and she put in 15 minutes. That's amazing use of billable hours. I love it. Anyway, our next speaker is Dan Feinstein. Dan is a partner at Davis & Gilbert, and he's going to be chatting with us about preventing employee harassment. Come on up, Dan.
Good morning, everybody. Let's see how I can find my way to... There we go. Okay, I'm going to start my discussion on employment harassment with a basic fact pattern and get everybody's reaction to it. And I have a feeling that this is a fact pattern that's all too familiar for the HR folks in the room. You've got an employee that comes to you and is very upset, distraught. And let's say it's a woman, a young woman, and she works for a senior male manager, and the manager was really unhappy with how she handled a particular assignment, and he really laid into her. He yelled at her, he was nasty, he was demeaning, just, you know, and a bit over the top. Nothing of a sexual nature, but really, as I said, really, really harsh. And this woman is very upset. Comes into your office, explains the situation, says that this has been a pattern of conduct with this particular male manager. He's constantly treating her in this way. She's had enough. He's creating a hostile work environment. And she's insisting on some sort of a transfer, where she's insisting that she go work for somebody else. Now you listen to her, and it certainly sounds valid. It sounds truthful, and you know this particular male manager, and you've heard similar things before about him. He can be over the top. He can be harsh. He can be nasty to people. And you're sympathetic to her situation, but there's really no place to move her. Just because of the staffing situation, there's really no place else for her to work. There's no other manager for her to report to. So you basically let her know that, you know, that she's going to have to continue to work for him, and maybe you'll talk to him, you know, or help her with the situation, but she's going to have to stay there. And she basically says that she is going to bring a claim for hostile work environment, for harassment. What do you think? Does she have a claim? She's being treated in a really, you know, tough and harsh manner, maybe even an abusive manner, yells, curses. She's demanded or insisted on a transfer to work for somebody else, and you're basically telling her that while, you know, you're sympathetic and you're going to try and address the situation, there's really no way to move her. She got a good claim? Yes. Yes. Okay, let's just get a quick show of hands. Who says yes? Okay. The rest of you, I'm assuming you're saying no, or you're just a little tired. Well, the answer is for the most part no. You know, the employment laws in this state, in this country, are still civil rights laws. You still have to show that you're being harassed based on a protected characteristic, based on sex or race or age or national origin, sexual orientation, or any of the other protected characteristics. There is still no such thing in this country, in this state, or in any states, of a sort of a general employment civility code. And a lot of people don't realize that. A lot of people think that there's sort of a general hostile work environment law, and that's not the case. These laws came about in the 60s during the civil rights movement, and what they were basically intended to say is that we're not going to tolerate, as a country, women being harassed because they're women, African Americans because they're African American, or because of your religion or your later on sexual orientation, or any of the other protected characteristics. They weren't intended to basically say, you know, again, we're going to mandate that people treat each other well in the workplace, or that they're not jerks in the workplace. So if you have that situation, that example I gave, you know, that's the classic equal opportunity harasser. The guy's a jerk, he's obnoxious, but he's that way to everybody. And that is still not unlawful in this country. Now, there has been a lot of discussion about this issue, and it sort of comes into the area of bullying. And that's a hot topic. You know, it's something that's very much at the forefront of discussions. You know, schools, it's obviously become a big deal through social media. And there has been some discussion about bringing the bullying concept into the workplace, so that changing the law so that it's not just about harassment or discrimination based on a protected characteristic, but if you have someone who is being abusive to other people, being cruel, being unnecessarily nasty, and it's significant, that in and of itself could be unlawful, even if it's not based on a protected characteristic. But it's important to know that currently the bullying laws haven't made itself into the workplace, and that type of conduct is still not illegal. Now, there have been some encroachments. California, for example, has basically made anti-bullying training mandatory. It's been the case in California for some time now that employment harassment and discrimination training has been mandatory for supervisors. But now what California said just as of January 1st of this year is that that training also has to encompass bullying training. And, I wouldn't be surprised if we see more of that. Maybe that's the balance that the government's trying to strike. Because I think we all get it. We all agree that bullying is not good, bullying is wrong, bullying shouldn't exist. On the other hand, if you can have sort of a general hostile work environment law or a general law of abusive conduct, and that could create liability, that's going to be a problem, right? You think about it, that example I gave, you have someone who works for a manager that's a jerk, and all of a sudden they're going to have a legal claim. Your guy's job's going to be a lot tougher, and the lawyers are probably going to make more money. But the reality is, it's a very, very difficult situation, and it's a tough balance, I think, for everyone to sort of strike. But it's important to know currently that those laws aren't there, and they're still civil rights laws. You still have to show the harassment, the discrimination is based on a protected characteristic. So just to review fairly quickly, the basics of harassment. There are really two types of recognized forms of harassment in the workplace. One is called quid pro quo. That's your classic type of harassment, this for that. In order to get this promotion, you have to go out with me. If you won't, engage in blank sexual act with me, you're going to lose your job. You're conditioning some sort of employment decision, some sort of term or condition on employment on some sort of sexual conduct. One of the classic cases there was President Clinton when he was the governor of Arkansas at the time, and he's allegedly up in a hotel room, I think it was Paula Jones, and he basically says to her, if you engage in blank sexual act with me, I'll guarantee you a job here with the state of Arkansas government forever. Of course, a lot of people said, what's the benefit there? But technically speaking, some sort of benefit. Sorry for any people here from Arkansas on some sort of job decision. The second type of recognized form is called hostile work environment. And that's where the conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment, and is directed at a person because of one of their protected classes. And this is very different. This isn't the quid pro quo, the this for that, but it's more about an environment. It's where you have an African American or a gay man or a woman or someone because of their age or their religion, and conduct is being directed at them, their protected characteristic, and it's really changing their environment. And that's what this is saying, that at a certain point in time, their environment has really changed. What could that be? Well, if we're talking about sexual harassment, touching, sexually suggestive verbal comments, jokes, gestures, explicit emails, photos, videos, discussing sexual activities, experience. And really what it is, as I said, it's not so much about a specific incident, but it's about an environment that's taking place at the workplace. And at a certain point in time, that environment is considered to be a hostile work environment. Now, of course, the big question is, at what point does it become a hostile work environment? We know quid pro quo is easy. Right? Manager says to subordinate, if you sleep with me, you'll get the promotion. That's illegal, right? We don't have to do a whole lot of examination and analysis. We all know that. But when it comes to a hostile work environment, when does it become illegal? Well, what if someone maybe makes one joke that's a little off color? Do we think that's illegal? No, right? Maybe inappropriate, but it's not going to be enough. What jokes do they have to make? And over how long? Does it have to be more than jokes? Does it have to be pictures? And the answer is there's no clear answer. It's not like I can sit up here and say, okay, here's the law in the state of New York. If you have 2 touches, 1 joke, and 3 emails in 4 months, or 3 touches, 1 email in 6 months, it's just not susceptible to that. And this is really, I make the joke a lot. This area of law, it's not brain surgery. Things that Francine was talking about, that's more technical in nature. There are very specific rules. A lot of this is more about common sense and judgment. And guess who's making those judgments? People like you, jurors. And that's the way that these cases go. You sit there and you listen to the situation and you hear the individual describe what her work environment was like as a woman, what his work environment was like as a gay man, what her work environment was like as an African American woman, and the things that they were subjected to. And you have to make a judgment call. The jurors make a judgment call. Sometimes it was like, yeah, there are some things going on there that I thought were inappropriate. That guy seemed like a little bit of a jerk, but I don't really think that they were in a hostile work environment. I don't really think it hit that level. If that's the case, there's not going to be liability. But other times it's, this was more than just a little joke here or there. I think it was pretty serious, and I think that their work environment was truly intimidating to them or hostile to them. It was really affected their work environment, and if that's their case, there could be liability. And you just don't know, and I always say that to people here. It's tough to really know. Some cases are obvious, right? We can recognize the really egregious cases, and we can usually recognize the ones that don't do it. But a lot of the times they fall in between, and that's really the challenge. The standard under federal law and state law is essentially severe and pervasive. Severe means serious, pervasive means ongoing. So really, again, what we're talking about is a course of conduct that's taking place in the workplace that hits a certain level. That's not just, minor or, middle of the road, but it's serious conduct, and that's the law under federal and state law. New York City is much broader than that. There was a case a handful of years ago where basically the courts came down and they said, you know what, in New York City law, it doesn't have to hit that severe and pervasive standard. Really what it means is that someone is being treated less well because of their gender or their race or whatever the protected characteristic is. And less well is a lot lower standard than severe and pervasive. And quite frankly, it's a little scary because that's a very, very broad standard. It's almost becomes, the way it really works is that the individual, the woman, the African-American man, the gay man, whatever the person is who's bringing that claim, has to show that they are being treated less well. And then it becomes the employer's obligation to show that it was maybe petty slights or trivial inconveniences, so that it was such a low standard that there shouldn't be liability. But unless they can show that, there can be liability, and this has really been a significant change for employers in New York City. There's a case that's been in the news just in the last week or two where a law firm was sued. A senior partner in a law firm was sued for sexual harassment by a young woman that worked there. And, a lot of the allegations were of the types we see, demeaning comments, sexual comments. There was some allegations of some aggressive sexual behavior. Basically the jury came back and they said that it didn't satisfy the federal and state standards of severe and pervasive, but they found liability under New York City. So it's a real significant issue. Now, when it comes to damages, if it maybe hits that standard, but it's really not that bad, there may not be a significant damage award, and that's what happened in this particular case. So you can have liability, but maybe if the conduct's not that bad, the jury will come back and give, some sort of a token award. So the severe and pervasive aspect of it is still important, but you should understand that in New York City, as lawyers and maybe HR professionals, we used to sort of rely on that. And I can't tell you how many times I've been on the phone with lawyers on the other side saying, yeah, I get it. I know that there are some things that went on, but it's definitely not severe and pervasive. Your client doesn't have a claim. Can't really say that anymore in New York City. It's a very, very broad standard. So now that I've sufficiently scared you, the question is, what can we do about this? What's important to understand is that for the most part, the law recognizes that employers can't be liable for everything that takes place in the workplace. It's not fair. We can't run our economy like that. There'll be just too much exposure for employers. So the law recognizes that and gives employers an ability to shield themselves from liability or reduce liability in a lot of situations. But that requires steps and that requires proactive measures for employers to take. Harassment's always going to take place. I say this to people all the time when I talk to clients. I say, look, I can come here once a week and do training for you guys. It's still going to happen. It's just, we can talk for a long time about why that is and psychology and alcohol and lots of reasons, but there are things that are going to take place. The classic example I give, again, turning back to former President Clinton, is, some people may like him, some people may not like him, some people may agree with his politics, may disagree with his politics. I think pretty much everybody would say he's a smart guy, right? He was a very smart guy. And you think about what he did in the Oval Office with Monica Lewinsky. For a super smart guy, you got to be kidding me. right? And that's just, it shows, and I see it all the time. Smart people who have done so much to, in their careers and to have gotten to a certain place, and they risk it for doing really stupid things. And, again, we're not going to go into why that is, but it's a fact. But my point is that the law, as I said, recognizes that, and the law gives employers the opportunity to, as I said, to protect themselves, to shield themselves, or reduce liability. So what are the things that you should be doing? First, you have to have a policy. I'm sure everybody knows that. It's very, very important. I say work with legal counsel. Of course, we're here. We have to give ourselves a pitch. You can work with legal counsel, but if not, there are things that I'm sure you can figure out on your own. It's got to be a written policy. You want to be talking about these sorts of things, making it clear that harassment and retaliation will not be tolerated, giving examples of the types of things that could constitute harassment. Very important to have a procedure. Who to go to in the event you believe you're being harassed or you witness harassment. A manager, human resources, somebody else of a senior nature. It's important to have more than one person, because sometimes the person who you go to is engaging in the harassment, or for whatever reason, you're not comfortable going to that person. So it's very, very important to set forth more than one person. Of course, confirm that harassment complaints will be investigated, that the company will take prompt and appropriate action. And, it's one of these things that I think it's important that not only you have a written policy, but that you get employees to sign an acknowledgement that they received it. Reality is, for the most part, you can show that you gave it to employees, or that you sent it out by email, that you put it in a handbook. But if there is a case, and if the employee didn't take advantage of the harassment procedure in the policy, it's really good to be able to show, here's the policy, here's when we gave it to the employee, here's their signed acknowledgement. I call it optics. But in a litigation, these optics are very often important. So these are one of those policies. I don't think every single policy an employee has to sign that specific policy, but this is one of those really key policies that I would say it is a good idea to have the employee sign an acknowledgement, specifically that they received that policy. Okay, so that's the first step that you should be doing, having a policy. The second step that you should be doing is that you should be engaging in training, conducting training. Not once a week, but not once every 10 years. I say periodically. What does that mean? Once a year, once every other year. There's some judgment calls that be made there. There's no, in New York, it's not that it says you have to do it once a year, once every 2 years, but you should be doing it regularly. And it's very, very important. First of all, we talk about lawyers and shielding liability and things like that, but sometimes we forget, part of the idea here is that it actually could be effective. So as lawyers, we sit up here and we say, well, it's very important so that if you're sued, you can show that you do A, B, and C to protect yourself. Of course, that's what we're being paid to do. But if you step back for a second, part of it is saying, if you conduct this training and you educate people and you make it clear to people that this is unacceptable, very often it's effective. Again, not to say that it's never going to happen, but people recognize it and people listen to it and people understand it. And I'm really always sort of amazed by that, that when you really see people understanding and people come out of these training sessions and say, wow, this really makes sense. I hadn't really thought about it for a while. And it's an opportunity to sit down, to force employees to sit down and spend an hour and a half every so often and really think about these issues and understand these issues. And I'm a big proponent in training. I've had plenty of clients say to me, well, I'm afraid if I do it and I educate my employees about these things, then they're going to start complaining or start bringing lawsuits. And I get that. I understand that. I think one of the things about training and a way to do it effectively is also to have employees understand that not everything's illegal. And a lot of employees, just like I started with that hypothetical in the beginning about the equal opportunity harasser, a lot of employees think it's illegal, and it's not illegal. And I think there's value in educating employees about these things. So the idea is not to discourage employees from coming forward. Of course, we want to encourage them, but I think that there's some value, as I said, to educating employees so that they understand the law and they understand that not every time someone says something to them that bothers them and that seems a little obnoxious, or that if someone curses, they think they have a good lawsuit. So I think that there's that aspect to it. I think that there's, again, an aspect to it of actually employees understanding and thinking about these things. I think there's an aspect of it that employees say, you know what, this company actually really does care. And, they're going through this exercise, and the company thinks that these things are important, and I think that there's value in that as well. From a legal perspective, there's clearly value. If you're going to be sued for harassment, very important, as I said before, to show that you're really doing what you can and that you're taking proactive steps. And training is a big part of that. So it's something that's very important. I think, I tend to think it's a good idea often to sort of have separate training sessions for management levels employees or supervisors, because there are going to be certain things that you're going to cover there that may not necessarily affect other employees. For example, what do you do if an employee comes to you with a complaint? You're not in human resources, you're not an in-house lawyer, you're a mid-level or manager, but very often they're in the front lines, and it's very important that they understand how to handle those situations. I mean, typically what they want to do is bring it to the attention of human resources. I don't think you want to encourage these people to go out and do the investigations themselves. But it's very, very important that they understand that, you talk about the company is aware, the company was aware of harassment. Who's the company? Take an example, Goldman Sachs. There's no Mr. Goldman Sachs, right? I mean, maybe there was at some point. But, when you talk about the company, for the most part, that means managers, human resources people. And so that if someone comes to a manager and reports harassment and they don't do anything about it, then that person's going to have a good argument to say that they informed the company. So it's very important that managers understand their obligations, and that's why I think it's important to, as I said, not only have generalized training, but also training for managers. As far as the training, again, you're going to be talking about these things, examples of things, and what they should be doing. Investigations, we can talk about this for a long time. The key is you want to conduct a prompt and thorough investigation. Someone comes to you with a complaint of harassment, you don't want to sit around for weeks and weeks and do nothing about it. You want to get on top of it quickly. Start looking into the situation. Find out what the complaint's about. Talk to the person who's accused of the conduct. Find out if there are witnesses. I think it's also very important to communicate with the person who brings the complaint. You need them feel, you're going to take it seriously, hopefully. And you need to make sure that they understand that. A lot of times I think that lawsuits come about because people feel like the company sort of blew it off or gave it short shrift. And I think as a human resources person, one of the most important things that you can do is, again, I use the word optics, but it really matters. Show this person that you're on top of it, that the company takes it seriously, that you're looking into it. Okay, here's what we're going to do. Thank you for bringing this to my attention. I now need to conduct an investigation. I'm going to talk to various people and then, keep them informed about what's going on. As I said, I think the communication aspect of this is very, very important. So again, talk to the accused. Talk to the person who's accused of the conduct. Witnesses. Generally speaking, you want to ask open-ended questions. What happened? Where did it happen? When did it happen? You're trying to gather as much information as possible. And then ultimately, you're going to have to make a decision. Or whoever's conducting the investigation. Do we believe the conduct took place? If so, you got to figure out what the disciplinary action is. And there's no set rules on disciplinary action. There's a 3 strikes, you're out. It's a judgment call. As an organization, what do we think we need to do to make sure it stops? If it's really, really bad, then it might be termination. If it's not that bad, maybe it's a verbal warning. If it's a little bit worse, maybe it's a written warning. If it's happened before, then you may have to come to the conclusion that, look, it's happened before. We gave this guy a verbal warning the first time. It continues. We got to let him go. But, there's no sort of set rules. I had a client recently had a situation where there's a guy that worked there, and good employee, 364 days a year, he acts like a perfect gentleman. At the holiday party, he has a few many too drinks, and he starts saying stupid things to young women. Okay? Happened the first year. Sat down, talked to him, and says, look, you got to stop, okay? Happened again the second year. I said, what are we going to do about this? Good employee, again, 364 days a year, he's an angel. So what do? We said, all right, well, you can't come to holiday parties anymore. You can continue to work here because every other day you're fine. Next year, holiday party, he didn't come. Year after, holiday party, he didn't come. Third year, holiday party, we said, you can come back. He came back, and he behaved perfectly. So the point is to say that's not what you do, but it's not about... it's about thinking about it. What do we need to do? Last point I want to make, the EEOC, they're being very aggressive. They're much more likely now, I've had numerous situations recently, they're coming on site and they're conducting interviews of individuals and saying to people, were you trained? They're saying to supervisors, tell me about your training. And I've had a lot of clients recently that, unfortunately, they haven't been able to do it, and it's becoming a problem. So just understand that the EEOC is becoming more aggressive, and they're asking questions, and when they do come, it's very, very important that you be prepared. You should be speaking to legal counsel. This is really your chance, if you have a good case, to try and avoid a litigation, and you don't want to give the EEOC short shrift and sort of blow it off because they come back with a probable cause finding, and now you're more likely going to be in a litigation. That's for me. Thank you. Thank you.
Thanks, Dan. That was really quite impressive. I've got some great news for you. Because we've already had 2 great presentations, we're going to extend things by a few minutes longer so that Blythe has a chance to really give us her knockout presentation. So I'd love to call up Blythe Lovinger now. She's a partner at Kasowitz Benson, Torres & Friedman, and she's going to be talking about navigating the post-employment restrictions. Thanks, Blythe.
How do you do this slide?
What's this? How do you do it?
Yep.
Just down button there. Next. There you go.
Okay, great. Good morning, everyone. And I will try to be quick because I know that people need to get to work. My topic is restrictive covenants, post-employment restrictions. And I'm wondering how many of you work for companies that have employees who are subject to non-compete agreements, by a show of hands. Okay. And how about non-solicitation agreements? And confidentiality agreements, how many of your employees are subject to them? Okay, so a fair number of you are familiar with restrictive covenants. For those of you who aren't, what are restrictive covenants? Broadly defined, a restrictive covenant is anything that prevents you from doing something. And in an employment context, such restrictions may include non-compete agreements, non-solicit agreements, or confidentiality agreements. Companies seek to have employees sign restrictive covenants in order to protect their business interests when employees leave the company. It's not only top executives who are asked to sign these types of agreements. Jimmy John's, a 2,000 location sandwich chain, has its employees sign a non-compete agreement, and Jimmy John's is not alone. There are reports of camp counselors and hairstylists who have employers who require non-compete agreements. Whether or not these agreements are enforceable is not a sure thing, and remains to be seen as they're challenged. But it is important to be aware of restrictive covenant agreements because they're not only for top executives. When do employers present employees with restrictive covenants? It could be when the employee is first hired in an employment agreement. It could be when the employee is promoted, is given a new position. They could come up in equity award agreements, in separation agreements, or in connection with the sale of a business. I'm actually going to forget about moving the slides along because, let's see. It's going to take too long. I'm not going to worry about that. Okay, so non-compete agreements. Let's just briefly talk about the different types of restrictive covenants. The first type are non-competition agreements. Non-compete agreements prohibit, for a time, the employee from competing with the company by providing services to or participating in the business of a competitor in a specified geographic region. Non-solicitation agreements. Non-solicit agreements can apply to either the solicitation of employees or the solicitation of clients or customers. And they prohibit, for a period of time, the employee from soliciting or hiring the company's employees after the employee leaves, or they can prohibit the employee from soliciting the company's clients or customers. The third type of restrictive covenant that we think of or that we see regularly are confidentiality agreements. These types of provisions protect proprietary and confidential information and protect against the use and disclosure of confidential information. They require the return of documents or other materials when the employee leaves the company, and these types of provisions are probably the most easily enforceable. Why do companies include restrictive covenants in an employment agreement or a separation agreement? It's to protect business interests. What are business interests? Client relationships, confidential information, goodwill. A company can't just ask its employees to sign a non-compete agreement as a scare tactic. And I make that point because years ago, I was involved in a case. I was representing an individual who was basically right out of college, working for a financial services company, and it was a small company. The head of the company had recently had a number of people leave, and he said, I'm not going to have people leave anymore. I'm going to have every single person who comes and works to work for me sign a very restrictive non-compete agreement. So this guy worked there for, I don't know, maybe 6 months. He went to leave. This guy said, I'm going to make him the test case. He initiated an arbitration action because it was subject to arbitration, seeking to enforce this very restrictive non-compete, and he lost. And, you know, the bottom line was the arbitrator said it can't just be, you can't just do this to scare your other employees or try to scare your other employees out of leaving. There has to be a legitimate business reason, and you need to be protecting something. In this case, the guy hadn't been working there that long. He didn't have access to many clients. The clients he did have access to were the same clients at his next employer, and it just didn't make sense, so it wasn't enforceable. So you really need to think about what your goals are when you're drafting a non-compete or a non-solicit or a confidentiality provision for that matter. You need to think about the scope of the restrictive covenant, and by scope I mean the length of time, the geographic scope. For length of time, for a non-compete, non-competes can generally be enforceable anywhere from 6 months to 2 years. Longer if it's in connection with the sale of a business. There's no black line rule. I can't tell you that definitely if you have a non-compete for 1 year, it will be enforceable. For restrictive covenants, it's not one size fits all. I did try to include a sample non-compete in my slide in the presentation, but you really need to know that even at the same company, it may not work for every employee. It really depends what the employee is doing, what his or her position is, what their responsibilities are, who they're dealing with, and then, of course, when it comes time to enforce it, perhaps how long they've been there. If an employee's been at the company for 6 months, a 2-year non-compete is not going to be enforceable. Unless there are some extraordinary circumstances. But again, for enforcement of non-competes, it really is very fact-specific. Sometimes we have clients call and they say, look, I have this non-compete, the employee left, I want to enforce it, what's going to happen? And even in the same court, with 2 different judges, you just don't know what's going to happen. You can get two different decisions. So it really is fact-specific, and also depends on what the trier of fact decides if it gets to that point. In New York, non-compete agreements are generally enforceable, provided that they are necessary to protect a legitimate business interest. For instance, confidential or proprietary information, company goodwill, customer-client relationships. And I say in New York because I don't know how many of you have, someone had asked previously, how many of you have employees in other states or in offices in other states? You need to realize that with respect to restrictive covenants, the law is very different or could be very different depending on what state you're in. In New York, non-compete agreements are generally enforceable. In California, they're not. So again, you need to think about where you are, where the employee is working, and what law is going to apply. Let's see. Okay. I'm trying to move this along quickly. Okay, so non-solicitation agreements. As I mentioned, there are non-solicitation agreements that apply to both employees and to clients. In New York, non-solicit agreements are generally enforceable. What a court would look at is the employee's relationships with the clients that the provision is seeking to prevent them from soliciting. And what's really important is that the employee's relationships with the clients if they were developed through the employment relationship. If the clients were introduced to the employee by the employer and developed at the employer's expense. People nowadays aren't necessarily at one employer for the length of their entire career. If someone's working at a company for 10 years and then goes to their next company and they already have a number of client relationships that they took with them to the second company, when they go to leave that second company, if they leave after a short period of time, the company may have a hard time arguing that those client relationships were somehow developed by the company or should be prohibited. Those client relationships should not be able to be taken to the next company. Of course, if the employee was at the second company for 10 years, there can be a very strong argument that the second company put in a lot of resources in further developing those relationships, and therefore the non-solicit may in fact be enforceable. So again, it really is done on a case-by-case basis. One thing for sure is that an employee's personal relationships, let's say childhood, friends, family, those kinds of relationships generally would be excluded or carved out from a non-solicit of clients. There's also a non-solicit of employees, and these types of arrangements are also seen. I can't figure out these slides, sorry. And I'm trying to hurry up. Are also seen quite frequently. And what's important with a non-solicit is that in the language of the actual provision, we often say that for whatever it is, for a period of 1 year after the termination of your employment, you agree directly or not to, on your behalf or on behalf of a third party, you agree not to directly or indirectly hire, solicit, or attempt to hire or solicit any employees who were at the company, let's say for the last 12 months that you were there. And the directly or indirectly language is very important because otherwise an employee can leave, go to his next employer, and just tell the HR people who to contact. Say, I can't do it, I'm prevented from doing this by a non-solicit agreement, but certainly you can contact and should contact John, Jim, and Mary. They're great employees, and here's what their comp arrangement was, and so forth. So the indirectly language is very important. That's key, not just actually with the non-solicit of employees, but also the non-solicit of clients. Confidentiality provisions, these are also seen regularly, and examples of confidential information that a company may be seeking to protect are trade secrets, computer models and algorithms, business and marketing plans, financial records, other financial, commercial, business, or technical information, information regarding product development, vendor, supplier, or customer list. When we're seeking to put together a confidentiality provision for a client, we really have to find out what the person who will be signing, the employee who will be signing the agreement does, what kind of confidential information they may have access to, and make sure to include that in the language in the provision. So again, it's not one size fits all. With respect to customer lists, we see a lot of discussion and litigation regarding whether client lists are truly confidential. If a company's client list is basically the phone book or everyone in the community, it's not going to be considered confidential. As an HR person, you need to think about it. If your company does not take steps or measures to protect its confidential information, they're going to be hard-pressed to, when it comes time to argue that the confidential information needs protection. If the company's confidential information is, let's say, publicly available on a website, then when an employee leaves and wants to share that confidential information, it's going to be very difficult to make the argument. So you really need to think about what measures or what steps you're taking to protect your confidential information. or the confidential information that you may want to argue is confidential when an employee leaves. Another issue that we see all the time is whether or not employees provided unique or extraordinary services to the company. It used to be more of an analysis as to whether or not the employee was actually unique or talented, if it was like Beethoven or Michelangelo, or, nowadays you think, well, someone can leave and everyone's kind of replaceable to some extent. But the focus today is less on the uniqueness of the individual and much more focused on the employee's relationship with the employer's business to ascertain whether or not his or her services and value in that operation can be said to be unique or extraordinary. How many of you have been in a position where you're hiring someone who was subject to a restrictive covenant? Okay, so when you're hiring someone and you find out, you should ask, they may not tell you that information, they may not be forthcoming, but when you're hiring someone who is subject to a restrictive covenant because you asked and they admitted that they were, you ask them to provide a copy of the agreement or the provision that contains that restrictive covenant, and then that's something that really should be discussed with HR, with in-house counsel, and perhaps with outside employment counsel as well. I mean, we see situations all the time where companies try to get around this. They say, well, the person had this title at the old company, so we'll just give them a different title at the new company and get around it, no problem. There'll be, a different title means different position. Well, not necessarily. You really need to think about what the person's job responsibilities were at their former employer and make sure that they're not, in fact, doing the same job, regardless of title, what they'll be doing for you at the new company, because you can run into problems. Companies aren't just going to, say, okay, the title's different, no problem. And that's something that we can talk about probably for 15 minutes, but there's really no time to do that. So let me ask one more thing. How many people have been in a situation where employees who were subject to restrictive covenants left the company? Has anyone run into that recently? Okay, for those of you who haven't yet, what I would suggest when that happens, you really need to get on it right away. You need to figure out if there are people remaining who the former employee worked closely with. I would suggest speaking with those employees, checking out the files, trying to figure out if the employee removed any of the company's confidential information. You probably want to consider a forensic analysis of the hard drive of the computer that the company used while at the company. You want to figure out if the company, or find out if the former employee is now soliciting any of the company's clients or employees to join him or her at the new company. You want to know if subsequent to their departure, the former employee met with or communicated with your employees on behalf of the new company, if the employee was doing work perhaps in advance. Sometimes people do that. They're planning a departure. They may be starting up their own firm. They may be going to a competitor, so they want to get a jump start, so they start doing work, maybe even working on projects, planning what they're going to be doing next, telling clients, telling employees before they actually leave. And when you get on this right away, you'd be surprised. Sometimes people will say, oh yeah, I was working last weekend and I saw John come in and download tons of information from his computer, or he was sitting at the copier for 2 hours, or he left with 2 boxes of information. And these are things that you can, you might be surprised, but you can find out if you do a prompt investigation. And also, again, computer forensics have also been very helpful when we've had to try to find evidence of an employee taking confidential information or perhaps soliciting clients or employees, because people mess up and they use their work email, or they send a lot of documents home to their personal email from their work email in their excitement to leave and start a new job. So this is kind of a rushed presentation here. If anyone has any questions regarding non-competes, non-solicits, confidentiality agreements, or best practices, I'm happy to answer them after we wrap up. Thank you.
Guys, so obviously we have no time for Q&A, but hopefully you all agree that that time was actually very well spent. So let's just join me in one final round of applause for our terrific speakers. So thanks everybody for coming. Please make sure you stay warm out there. We'll see you on March 27th, and kindly return your polling devices to the ushers as you walk out. Thanks again.